Hereby call to order this meeting of the Sahuarita Town Council. I'd like to inform everybody that it's being broadcast live and will be recorded for future viewing. And I did want to take a point of personal privilege tonight, and wish Councilmember Morales 39 years plus 1 day. Happy birthday. And I'm sticking to 39 over and over and over again, just like me. Tonight after the pledge, we'll have our joint study session with the Planning and Zoning Commission. Thanks for showing up in front. And Leah Rhodes, our Deputy Town Clerk, will lead us in the invocation, followed by the Mayor and Council leading the Pledge of Allegiance. Leah?
Lord, we are meeting tonight to conduct matters of business. Guide our hearts and our minds in the spirit of fairness, right thought, and speech. Impact your supreme wisdom upon our activities so that our affairs may reach a successful conclusion. Thank you for being our source of guidance tonight. Amen.
Amen. Thank you. Please join me in the pledge. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Thank you. Madam Clerk, may I have a roll?
Councilmember Bracco.
Here.
Councilmember Davis. Here. Councilmember Gillespie.
Here.
Councilmember Morales. Here. Councilmember Priolo. Here. Vice Mayor Egbert.
Here.
Mayor Murphy.
Here.
Quorum present.
Thank you. And I'm going to be, we only have 2 items, so I decided to flip the 2 because I thought it was important to start with the open meeting law training. This is a study session, joint meeting, touch on some of those things, and then go to, and which probably won't take as long as the other item. So at this time, Madam Clerk, will you read item number old 6, but new 5?
Before we do that, would you like the chairman to open their meeting?
Sure, that would be fine. Vice Chair, if you'd like to, acting chair this evening, if you'd open your Planning and Zoning meeting.
Thank you, Mr. Mayor. Madam Clerk, roll call for the Planning and Zoning Commission.
Commissioner Magrin? Commissioner Maynard? Here. Commissioner Millett?
Here.
Vice Chair Mayor Montes?
Here.
Chair Backer? Quorum present.
Thank you. And at this time, if you'll read item number old 6, new 5, please.
A joint study session of the Town Council and Planning and Zoning Commission to provide Arizona open meeting law training.
Thank you. And Mr. Palladini is our town attorney and will be providing this training for all of us.
Mayor, Council, and Commission members, I figured I'd do it from here since I'm better on my feet. Can we load the PowerPoint? Is it up? There it is. Okay, cool. All right, so this is your open meeting law training. If you ever get into trouble from the Attorney General's office, it's your fault, not mine. I've given you this training, and we recommend to do this annually, not just to take in new members of a board or commission or council, but kind of as a refresher, because things do change a little bit. Every once in a while, the legislature likes to dabble. So what's the purpose of open meeting law? Open meeting law is to do the public's business in public, which means that what's the saying, that sunshine is the best disinfectant, right. And so the government's business is done in public. Arizona, some states call them sunshine laws. Arizona's just called OML, or open meeting law. And so we do the public's business in public with some exceptions, and we'll get to those in a bit. Well, I can't read that. So let's start with, what is a meeting? A meeting is a quorum of the membership of the board or commission. So for instance, you have a 7-member planning commission, although you only have 5 seated members at the time. 4 is still the majority or quorum of that panel. So if you're, if only 3 people had shown up tonight, even though it's a majority of 5, it's still not a majority of the board, which is 7. Same with the council. So what happens if you don't have a quorum? You can't have a meeting. You can't You can't talk about the topics that are on the agenda. You can't have an informal session because the potential of having an open meeting law violation exists once you do that. So if for whatever reason a quorum doesn't show up, you just have to cancel the meeting and reschedule the items for the next time or the next available date. So notice an agenda. These are things that your clerk is going to do for you. You could only talk about about that are things that are listed on the agenda. So we try and avoid generic terms like new business, or if you have an agenda topic, some places do agenda ideas or requests to place on an agenda. That's fine, but the purpose of that is to suggest, I want to put this item on a future agenda for council or commission discussion. But that's where you stop that discussion. You can't go beyond that and say, because I think this or I think that. So those are we try and avoid those. The other sort of pitfall that we run into is the call to the public. The one city I worked at, Prescott, I think was the only one in the state. We didn't have call to the public because it was such a high risk of having an open meeting law violation. And so it takes, and every time Mayor, you read open or the call to the public, you give that admonition. The council can't respond. You can respond at the end, but only in these, only in these kind of particular situations. And in fact, the Attorney General historically has recommended against the call to the public. That doesn't mean you can't do it. You just have to be very careful. Make sure you don't respond to comments that are in call to the public. Additionally, call to the public is intended for items not on the agenda. So that means that, and we'll get to this in a little bit, there's open meetings, which are all meetings where a quorum exists, and there are public hearings. And public hearings are a subset of open meetings. All public hearings are open meetings, not all open meetings are public hearing, which means that when you don't have a required public hearing, like a rezoning, truth in taxation, annexation, those kinds of things that are statutorily required to have a public hearing, it's up to the chairman or the mayor to allow or not allow public comment on the other items on the agenda. You're not, and we'll get to this too, you're not required to take public comment items that are not agendized as a public hearing. So what are some of the exceptions to this notice and agenda? If there's a real or actual emergency. You don't think of it necessarily here, but if we had, when I was in Prescott, we had a snowstorm. I mean, literally a snow emergency, snowmageddon they called it. And the council had to meet because there was a declaration of emergency. So those things happen every once in a while, fires, where the council has to get together and have a meeting about about the thing that is the subject of the emergency. You can't slide in other business into that. But those are real rare and a real exception to that rule. Who must comply? Everybody must comply. Council, commission, subcommittees, committees, subcommittees of a committee, working groups, no matter what you call it, if the public body appoints a subset of the body, or if the mayor appoints a subset of the body to look into something in particular, whether it's a research or a report to come back or make a recommendation, those are all of those subgroups are subject to open meeting law. So we kind of recommend using those sparingly, because as you can imagine, trying to comply with open meeting law with the council and a commission is a challenge for your clerk. The more subcommittees and subgroups you have, or the more commissions you have, the more challenging it can get to keep all of those straight. Sahuarita is sort of a little bit unique and has planning commission. Prescott had 27 boards and commissions. Wow. So you can imagine how tough that was. And not all of them met regularly, but it's a huge challenge because all of those have to comply with open meeting law. So somebody's got to make sure that you're doing that right. So, like I said, if you use those sparingly as a practice, because it does become a challenge to make sure you're complying with open meeting law, agendas, notices, those kinds of things. So what do you do at a public or open meeting? You can discuss and decide. That's essentially what you do. Or you can just discuss, items where there's no action recommended. So we do that quite a bit here during the regular meetings. There are discussions or presentations where there's no action to be taken. Sometimes there's direction or consensus as to what we're going to do next. And those should be agendized as, discussion and possible direction. It's a little less than a formal vote, but it gives the staff the direction, okay, what are we going to put on the next agenda or at the next meeting so that we can then make a formal decision on it? Because sometimes there is, you need direction from, staff needs direction from the council. Somebody said, God darn it, if it weren't for these open meeting laws, we'd be able to get so much more done because we could talk to each other. I'm not going to tell you which one of you said it, but somebody did. And again, that's and I get the frustration with open meeting law and the rules that you have to go through, but that's exactly the point. You're not supposed to get things done outside of the view of the public. That's the whole purpose of open meeting law. Okay, real quickly on exec sessions, I'm going to separate the commission out. You should never have an executive session, so just throw it out of your brain. If there is a reason to have an executive session, it has to be, it's going to have to be basically for legal advice. So we may get there, but they should be very rare. For the council, there's all kinds of things you can have an executive session on, whether it's employment issues, whether it's legal advice, whether it's a business transaction, to give direction, to negotiate. And the reason for that, for those kinds of executive sessions is if you had to do it in public, it would be kind of silly to instruct your staff, hey, go buy that property, offer them $800,000, but you can take 1.2 million, or we'll take 1.2 million. It doesn't really make any sense from a negotiating standpoint. Think of it as you're going to buy a car, and you and the spouse are talking, and the salesman's listening in, to what you're saying. Well, offer him 50, but we'll go to 60. I mean, it doesn't really make any sense, right? So that's the reason you do those in confidence. And at executive sessions, you also be very careful that the staff present, attorney, manager are always going to be there. Your clerk's always going to be there. The only staff that are allowed in the exec session are those necessary for that particular topic. So as this council knows, you'll have 2 or 3 items on an exec session. Some staff leave, some staff come in, and that's how it's done. And that's doing it the right way. You don't want to have a bunch of strap hangers in the exec session who don't need to be there. The other thing about exec sessions, I already talked about this, is that you have to treat it as if it is a classified briefing. And I know you know what that means. Mm-hmm. You cannot discuss what goes on in an exec session outside of the exec session. You're all given an admonishment that you're not supposed to discuss this outside of the exec session. You can't use it for any purpose other than the purpose that you get the information in the exec session. It can be an act charged as a criminal act if you disclose it, particularly if it's for personal gain. So that's why we always give the admonishment in an executive session, and we always remind you, do not talk about this outside of this room, even after that, even amongst yourselves, because you don't want to have this further discussion go down the road. All right, so what's legal advice in terms of exec sessions? 'Cause that's going to be your primary topic for executive sessions. You do have things like negotiating with collective bargaining units. You have one that says you can talk about documents that are by law you're allowed to keep confidential. So for instance, infrastructure documents now are protected from disclosure under public records law because it's sort of a security issue if people know, particularly if you're providing water. You don't want people to know your secrets about your water distribution system. The town doesn't have that, but that is a basis. So what's legal advice? Legal advice is the lawyer giving you the law on a particular topic. And the point of the exec session, by the way, isn't to debate and decide what you're going to do. It's to get the legal advice, get the information. You can give direction, for instance, on a lawsuit settlement, on a business transaction, but the ultimate decision has to be done then in an open meeting. So again, we talked earlier about some sort of real estate deal. You give staff direction, staff goes out and negotiates the deal. It has to bring it back, staff has to bring it back to the council, and then you would approve the deal in an open meeting. All right, so let's avoid pitfalls of open meeting law. This is the part where I'm going to tell you, don't do this stuff, okay? So don't poll. You don't want to go around. How are you going to vote? What do you think? And there's no horse trading, by the way. This isn't Congress or the state legislature where you can go, if you vote for mine, I'll vote for yours. You can't do that in this kind of context. By the way, I mentioned the state legislature. The state legislature exempts itself out from most open meeting law requirements,
Sure.
even though they create the law in the statutes. The other thing that you want to do, a couple things you want to do, is at the end of meetings, kind of be careful about talking about things that may look like you're still talking about an item. Because again, you have hot mic issues. You also have potential to further discuss items that are now outside, the earshot of the public. So you want to be careful about how you talk on items or on topics that not only are going to come up on an agenda in the future, but have the possibility or likelihood, and it doesn't have to be a high likelihood. It's something that is going to be addressed by the council or could be addressed by the council. You want to have sort of avoid that discussion amongst yourselves. And we'll talk a little bit about how you can run into problems with open meeting law just by talking with one other person. Okay, so this is it too. You can't poll, and you want to avoid deliberating, deciding outside of the meeting. So a couple of things that happen, and this is really common, not so much in person. There used to be a game called telephone tag. I don't know if you can do that with cell phones anymore, but one person would tell another person something, and then it gets passed on, and the person at the end of the row repeats the story back to number one to see how much it changed, on the path. Well, you can't do that under open meeting law. You can't a meeting can occur. It doesn't have to be simultaneous. It can be consecutive. So you want to avoid having. That's why you've got to be very careful if you're going to talk to one other person, and then each of you talk to one other person. That's four, and that could constitute a meeting. So when it comes to open meeting law and public records, I like to be very conservative about it because it really doesn't do anybody any good to have a member of the public file a complaint with the Attorney General's office that they call OMLET, their open meeting law something, education team or something like that. But the point is whenever you get an open meeting law violation or a claim that you violated it, it takes a lot of work to respond to it, to determine, to tell the AG's office why this wasn't a violation. Or sometimes you have to tell them it was mea culpa, and then we'll fix it. And most of the time the fix is going to be you have to sit through one of these again from somebody else or myself, which is really painful, to sit through it again. So the point is you want to be very careful about circumvention. There's the hub and spoke, where you have one person goes to every other person and kind of does polling or finds out and then relays back and forth. There's what people call daisy chain, which is one after the other after the other. It's easier to avoid that when you're doing in-person discussions because you're kind of aware of it. It's harder now that email is so common because the infamous reply all button it's a terrible tool when it comes to trying avoiding open meeting law. Because what happens is somebody will send an email, like a staff member will send an email, and it's so common where somebody will respond back. Some of them, the board members, commission, or council, will respond back to replying all and asking a question or making a comment. And all of a sudden, you've just had a meeting. You've just had a discussion about the topic. So You know, there are little tricks and things where you can send things, like the sender can put everybody in the BCC line, and that prohibits the reply all. But you have to be aware, don't reply all. Even if it's, you know, even if the question goes out, hey, we're having a meeting, and you can either attend virtually or you can attend in person. Tell us what you're doing. Even then, don't hit reply all. I'll be there in person. It doesn't do it. Everybody else doesn't need to know. So just avoid that whenever it comes down to, you know, business of the town. So the two-way communications we're trying to get you to avoid are discussing, deliberating, which means sort of debating, taking legal action, which means making a decision. Doesn't have anything to do with lawyers or law. Taking a legal action is that conclusory action you're going to take essentially to vote on something or give direction on something. You want to do that in the meeting. And so we have two-way communications back and forth. You have one-way communications because one person can suggest by way of an email to everybody else an outcome or a proposal that could constitute a meeting. It doesn't require a response. So again, you have to be email is a really dangerous tool. It's a great tool, and it's great because it replaces a lot of meetings. But it can be tricky, can be risky to use it if you're going to be sending emails to your fellow board or commission members or your council members. So here's some examples of what proposing legal action is. You know, if somebody sends out hey, Councilman Smith's in the hospital, that's fine, you know, to send that out. It's not proposing any legal action, but we need to install a crosswalk. That's proposing some kind of decision. It's different than, can we put on the next agenda, you know, a crosswalk at this. And again, it all depends. So these things really do depend on the procedure that you use for putting things on an agenda. Typically, it's going through staff to put something on an agenda coming up, usually through Shane or something. If there's a topic for discussion that a council member or members want to put on another agenda. Never ask for votes on something, even if it's very important to you. So avoid the, you know, and the other thing we want to do is we want to avoid providing information's risky. So in this example, you have, hey, here's an article on a program that they're doing in Oregon. I don't know why anybody would want to do something they're doing in Oregon, but this is just the example. But if there's a comment that goes along with, like, I really like this, or we should do this, then you're proposing an outcome or an action. So again, be very, very careful if you want to share information and share details. What I would suggest is if you have something that's really you think the rest of the council should know or should be informed of, use the staff to provide the information saying, hey, Shane or Lisa, I think the rest of the council should see this, because what's going to happen is if the staff distributes it out, they're going to sort of edit your comments out, and it'll just be this neutral piece of information that goes out to the remainder of the council or the commission, rather than you send it yourself. It's very tempting to just make a off-the-cuff comment. So we got to be careful about that. We want to do all of our business in public. So more legal action. I always love this one because it's about the manager. So, you know, we need to discuss the manager performance versus, you know, we need to discuss.
You didn't edit this, Shane, before the presentation?
This is my favorite because it's not the town attorney. So, this is a good example of, you know, we need to have a review versus we need to do something, we need to take some action. So it's just those kinds of things. You got to be just the words you use and the way you say things, whether it's an email, particularly an email, can come back to haunt you. So there is no difference between facts and opinions when it comes to a potential meeting. You can state, if you want to say, these are the facts on this particular item, you have to be versus these are my opinions. It still runs the possibility of violating open meeting law because you may be looking for a particular outcome. So like I said, I stress use the staff to share information that you have. Don't send it directly to the rest of the council. And by the way, that also helps staff know what you're all getting too. So it's kind of, there's a couple of benefits to that. So serial communication is just, we talked about this going from one person to another. Nonverbal, which we talked about, nobody writes letters anymore, but email, we talked about this too, doesn't have to be simultaneous. It can be, a serial, literally one after the other. So in the same way, we talked about this, you can't do it in person. If you can't do it in person, you can't do it by email. You can't do it by text. We'll get into social media in a bit because it's a little quirky, but don't do it by social media either is kind of the bottom line. We talked about that. Don't use the staff or don't ask the staff to violate open meeting law for you. You're not, so there's, unlike the tax code, we're trying to avoid loopholes. We're trying to make this very easy and simple. Don't violate open meeting law. Don't try and figure out, don't be the smartest guy in the room because you're not, you're gonna get in trouble. Because inevitably, part of the training that I do, that we won't do it tonight, is public record law. Well, everything you do, particularly in writing, is gonna be part of the public record so people can find it. So just be very careful when you're doing that. So social media is a challenge. Because I'll define it two ways. If you're using an official Twitter or an official Facebook, the town's or your official as the mayor or council member or vice mayor, you have to be even more careful because it's what's called a public forum or a limited public forum. So it actually becomes, kind of like town hall, electronic version of town hall. So you have to be very careful about using official social media. It can be very, very tricky. And so I would recommend not even having it if you can avoid it. Or have, again, a staff person who's trained in public relations and public communications to sort of be the person who runs that the town social media. Your own personal social media, Facebook, Twitter, Instagram, Pinterest, whatever else, you have to be very careful on those too. Because if your friends or maybe even LinkedIn, but if your friends or you're following or you're doing this, you have to be sort of, if you suggest something's coming up on the agenda tonight and a lot of people will ping you, vote no, vote no, vote no. And you kind of say, I'm going to fight this, we're going to vote no on this. All of a sudden, you may have 2 or 3 other council members or commission members or your friends who can see it. And all of a sudden, now you're telling them, not only am I going to vote no, but here's why. And so social media is really, really tricky. There haven't been, in Arizona in particular, a lot of cases that have dealt with social media and open meeting law. So I think the best advice I can give you is just err on the side of caution. Treat it as if it were an email or a letter or face-to-face conversation. Again, because we don't require the conversation or communication to be simultaneous. It can be consecutive over time.
John,
Yes.
do you feel it's safe just to give information out to the public as long as we don't comment on an opinion on our?
If you're going to provide facts or information, I would stress to be very cautious about how it's done. And I would also suggest that if you're going to provide information, you have to sort of make it clear that this is me. This is I'm not speaking on behalf of the town. This is not an official Facebook page. This is me. I'm providing this information so it's very clear. But I would avoid in those situations stating an opinion or calling people to action or whatever it is you want to do. It's just we'll get to the weird quirk. We'll get to in a minute, but I just would recommend erring on the side of caution on internet and social networking. We already talked about this. So here's meeting etiquette. So meeting etiquette, passing notes, whispering. This is really not open meeting law per se, but it kind of triggers it a little bit. That if you're whispering to each other on the dais, and people in the audience are like watching, what are they talking about? And it could be, God, I hope they get the pizza here pretty soon because I'm starving. Nobody knows that, if you're whispering to each other. So you're kind of trying to avoid that, whispering to each other, passing notes. Using your phone on the dais for you all is really bad because, you might be texting, hey, the meeting is going to go forever because the lawyer wouldn't stop talking. But who knows what you're texting, especially if somebody else pulls up the phone and starts typing and texting, are you talking to each other? And if you're talking to each other, why aren't you doing it publicly? So it's just it's a meeting etiquette thing, but it's also the appearance of, the lack of openness when you do that. So just be very, very careful about it. And I mentioned this before meetings start, after meetings are over. It's so commonplace that you sort of have conversations or wind down and chat. Just make sure you're not talking about the things that are either going to be on the agenda or that were just on the agenda. So again, it's all about doing things in public.
John, we have a question, I
Sure.
think.
So I have a question. So I can understand that this is a communication between the commission or between the town council, the commission, or within the town council. Members of the public often would like to say something after the meeting officially ends.
Mm-hmm.
That type of communication is not directly to members of the commission, but individually, and they often would just, they have something to say.
Sure.
So you're going to respond.
Yeah,
to that.
that's usually not a problem. I mean, again, it's not a black and white type answer to those kinds of things. You don't want to be rude to someone who comes up to you and says, hey, did you, when you voted for this, did you know this? Or those kinds of things. And usually if the decision's done or already been made, it's less of a potential problem. If you have a study session, that you haven't decided on the item yet, be a little bit more careful about it because typically, especially in the zoning context, most of your meetings are going to be either required public hearing or typically the public, comes up and speaks. Rezonings, conditional use permits, those things, they require a public hearing. So if you're doing a study session, just be a little careful about, if the public approaches you, at the end of the study session before the decision's made, that you don't want to, particularly if other commission members are within earshot, because it's really tempting to have a conversation and all of a sudden 2 or 3 of you are having a conversation and then it just takes one more person to have that meeting. Okay, social events. Again, this is one of those things, smaller communities, it's very tough. People go to social events. You're not required to sit at separate tables, particularly if, the town has a table and the council's going to be there. That's, what usually happens is a courtesy notice or a quorum notice gets put out. Hey, a majority of the council might be at this event, but they're not going to talk town business. And when we say that, we kind of mean it. And it's very difficult sometimes because usually you're there for the reason of talking something relative to the town, but you have to avoid, as best you can, talking about things that are coming up on an agenda in the near future. The hardest one is the mayor's state of the town kind of speech, because it's literally talking to the whole council about, and the public, about, not only what's gone on for the past year, but what the prediction is for the coming year. And typically, those are best agendized as a meeting. But the whole topic is mayor's annual speech or whatever, state of the town. So, and those are things that can be sort of fixed or cured by agendizing it right. But some things that are just social type events, weddings or what have you, where a majority of you might be there, you're not prohibited from sitting with each other or chatting with each other. Just, leave the business aside and just have fun and do what you want to do. So I think we talked about that. Okay, here's where it gets kind of quirky is the First Amendment trumps open meeting law. So you are allowed to talk to media, and now that's a big gray area, right? I mean, but you're allowed to talk to the reporters or media or go on the radio or whatever, and they can ask you, hey, this is coming up, on the next meeting. What do you think of it? How are you going to vote? I mean, and usually the best answer is, well, I want to hear from the applicant. I want to hear from the public. I want to be open-minded about this. I've got some concerns. But you could still say, you know what, I'm absolutely against this and I'm going to vote no. And if the rest of the council is listening in or the rest of the commission is listening in, you're not violating open meeting law because the First Amendment allows you as an elected official or an appointed to make those kinds of comments to the media. And like I said, we were looking at sort of more traditional type media. And there hasn't been any cases that have said, well, that translates into social media. So just be cautious and aware that when you say something, to the media, and the other issue talking to the media is this: you may think, I just gave them a great statement, and they especially audio, and then they chop it up, and either they make it sound like you said something opposite, you sound like an idiot because they chopped it up, and even in print media, I can't tell you how many. It's not just small community papers, but where quote so and so said quote, and I'm like, I didn't say it that way. I mean, I've been quotes around things I've said that I didn't say. So we've all probably faced that. So you got to be careful about talking to the media. Just be aware of it. Like I said, particularly if you're going to do any kind of broadcast, they're looking for 7 seconds. So if you go on for 35 seconds, 45, a minute and a half, you're going to get chopped down, and who knows what they're going to broadcast about what you said. Print media is usually a little bit better. You can go into more detail, but again, nobody's perfect, and oftentimes they get it wrong. So you're not prohibited from talking to the media about things that are coming up. Just be careful and be aware that what you say isn't necessarily what's going to get reported. So, kind of winding it up, the public's rights. So in Arizona, like I said earlier, we have open meeting law. And open meeting law requires the public attendance. The public can attend an open meeting. There is no right in Arizona to public participation or public comment unless it's a required public hearing. And like I said before, those are land use issues, annexations, truth in taxation, those kinds of things are statutorily required to be one or more public hearings. That's when you have to allow the public to comment. And again, it's not a free-for-all. That you can place reasonable limits, 3 minutes, 2 minutes. It's kind of up to the mayor or the chairman to decide what the parameters are going to be in those public hearings. It doesn't mean that if something's agendized and it's not a public hearing that you can't take comments. It's just you're not required to take those comments at a open meeting that's not deemed a public hearing. So the public has, unless it's a public hearing, no right to speak, and it certainly doesn't have a right to disrupt. And certain times, I've seen mayors either gavel the meeting over, we're done, because it's just been so raucous and disruptive that it was, there was almost a fear of concern for safety. Or the better probably, or the more moderate, is to just let's take a break. If you're running the meeting and it feels like it's getting a little heated, particularly if there are two sides two sides debating between each other, it's probably best to take a break, let everybody cool down, and maybe talk to your police officers about keep an eye on that guy or those guys or those people. So that's so those are the things we kind of have to be aware of when we're running a meeting, is, use your common sense. Is it getting heated? Should we take a break? Because you're better off probably letting people kind of cool down a little bit and then come back and redo it. And sometimes, most times it tends to work. So, last slide. When in doubt, always err in favor of openness. Always try and do things, the public's business in public. And I'm here and your staff is here to help guide you to avoid open meeting law violations. And if it does happen, there are ways to cure, it's a little detail, but there are ways to cure the violation, of the potential violation, without being too serious. Real quick story, and then I'll sit down. And that is, there was a town council north of here, somewhere northern, actually north of Phoenix, and there were 5 council members, and they thought they were the smartest people, or maybe I take that back, there were 7. So they thought they were going to outsmart the law. And so 3 of them met in a coffee shop, cafe, talked about things, and one waited out in the car or the truck, and then one guy would get up and he'd leave, and the guy waiting in the truck would come in and they would have that conversation, and they just sort of did this round robin thing. Well, what they thought they were so smart, and yet everybody knew them. It's a small town, so people got kind of suspicious. And then they were reported to the Attorney General, and it was found out that this was such an egregious, intentional act, they were actually removed from office. So a serious violation of open meeting law can result in removal from office. And so, like I said, you're more, and this is no criticism of anybody, but you're more than likely not going to be able to outsmart the open meeting law, gremlins out there. They'll find out one way or another. So, and I think that is it.
Thank you, John. Any questions or follow-up from my left? Am I right?
Yeah, good.
P and Z, any questions? And John's always available, so as we move on, if there's any questions, I know he's very open to getting that type of feedback. Thank you, John. Appreciate it. Madam Clerk, old number 6, new number 5.
A joint study session of the Town Council and Planning and Zoning Commission to provide an overview of the conditional use permit application submitted by the Vulcan Materials Company and conditional use permit CUP process training.
Thank you, and Ms. Cassidy, Anna is our Planning and Building Director, and will be presenting this item. Good evening, Anna.
Good evening, Mayor Murphy, members of the council, Vice Chair Miramontes, and members of the commission. Happy to have you all here tonight. The purpose of tonight's meeting is to inform the council and commission about the conditional use permit process, and you'll hear us refer to that as a CUP frequently. So when you hear CUP, that's conditional use permit. We'll provide you with some background information on the Vulcan property and provide some basic information on the Vulcan CUP application that's currently under review for a hot mix asphalt plant on Old Nogales Highway. The purpose of tonight's meeting is not to provide any analysis, recommendations, or decisions. The application is still under review and analysis is ongoing. So once that analysis is complete, we will schedule public hearings, and that analysis will be presented along with a recommendation at a public hearing. We'll start with a little timeline of the area. The map that you see up on the screen is a zoning map. The yellow star is the approximate location of the proposed hot mix asphalt plant. The entire area has likely been zoned RH, rural homestead, for many decades. The RH on the map is the green. So everywhere you see green, that is zoned RH, rural homestead. Rural homestead is considered a holding zone. That is a zone that property owners rezone from, not to. My guess, and it's just a guess, is that when Pima County adopted their zoning map way back when, that they zoned any area that was either vacant or agricultural as RH, just waiting for growth and development to come along, and for property owners to rezone to something that allows more density or intensity. Quail Creek was rezoned from RH to SP, which is specific plan, in 1989 through Pima County. Looking at some old aerial photos, you can see that mining on the Vulcan property is clearly in operation back to 1996. Going all the way back to 1985 aerial imagery, you can see that there's disturbance on the site, but the imagery is blurry and it's hard to tell exactly what's going on over there. The entire area, including Quail Creek and the Vulcan property, was annexed into Sahuarita in the year 2000. That same year, Quail Creek doubled its footprint and moved a little closer to Vulcan's site. Vulcan acquired the site from the previous owner in 2015. So we are reviewing an application by Vulcan Materials for a hot mix asphalt plant. There's currently a sand and gravel operation going on that site. Vulcan Materials owns the site, and they applied to us to use their existing sand and gravel operation site and to add the hot mix asphalt plant use. We are required to review and analyze the application, to hold public hearings, and to make a decision. Reading through a lot of the public comments that I've received, I'm getting a lot of, like, why are you even considering this? While the property owner applied to us for a use that's listed in the zoning code as a conditional use, we don't have the option to just say, no, we're not going to review it. We do have to conduct the analysis and go through the whole process. I'm gonna hand the floor over to John, and he's gonna talk a little bit about the legal aspects of conditional use permits.
So, Mayor and Council and Commission, here I am again. We talk about a use permit and give some context that there's a sort of a spectrum of discretion that the town has when it approves land use decisions. So on the most discretion side is a rezoning or a text amendment to the zoning code. That is considered a purely legislative act, which means that the council, or ultimately the council, has pretty much unfettered discretion to approve it, deny it, or approve with some type of conditions. Obviously, there are certain limitations on an approval. There can be illegal conditions, unconstitutional, basically, conditions. But other than that, on the discretion, that's the most discretion that the town has. On sort of the other end of the analysis is something like approval of a final subdivision plat. It's very, for lack of a better description, it's like a math equation. Did they do all the things they're supposed to do for this final plat, so it's in substantial conformance to the preliminary plat that was approved, and subdivision plats are very engineering and those kinds of things. So even if you don't like ultimately the way the streets are laid out, as long as it meets the required code, you must approve it. A conditional use permit is somewhere in between. It's not considered a legislative act, it's more of an administrative approval. And so that's where you have some discretion, or you have discretion to impose conditions on the use that is being requested. So in this particular zoning, an asphalt plant is a conditional use. You can go next slide. So a conditional use is a use that it is permitted within the zoning district. So a sand and gravel operation would be a permitted use in this district with a conditional use permit. In this particular instance, because it was an operation prior to the town incorporating and prior to the town annexing that property, they didn't have to go through a conditional use permit. It's called a legal non-conforming use. Some people call it grandfathering, but essentially the property rights trump zoning, essentially, in that case. This asphalt plant is also a permitted use subject to conditions. So, and the reason you have the ability to impose conditions on a use is because of the potential adverse impacts of the particular use. Next, please. So, like I said, this is a use which, due to its potential for nuisance or hazard, than other uses in the zone, you can impose conditions on it. The conditions you talk about, or the conditions you impose, have to be related, a couple of things. They have to be within the jurisdiction of the town, and they have to relate to land use impacts. Next slide.
John, just to interrupt on that point, because they have to get an air permit, and we have something called Pima County Department of Environmental Quality and Arizona Department of Environmental Quality 80 EQ. that lands in their jurisdiction.
Correct.
Because that's the governing body, so to speak.
Right.
Of those types
So
of things.
we'll talk a
correct?
little bit about that, Mayor, but for instance, I know I've seen a lot of documents and letters that talk about OSHA, or in Arizona, ADOSH, which is the OSHA delegated authority to Arizona. The town has very little, if any, authority to regulate workplace safety that aren't town operated. In other words, you obviously have, but even the town's operations are regulated by ADOSH in terms of workplace safety. So the town doesn't have jurisdiction to impose conditions in a conditional use permit, for instance, that would relate to workplace safety. Same with water, for instance, is usually regulated by ADWR. So if there's a well on the property, that's going to be a registered well, most likely, and Arizona Department of Water Resources, is going to regulate that well. So the town obviously isn't a water provider. We talked before about that if this permit were to, or this plant were to be in operations, that Vulca would have to work a deal with the railroad to get a crossing over the tracks. That there's two issues there. One is the railroad itself has to agree, and second is there's a process through the Arizona Corporation Commission to get approvals for additional crossings like this. So that's a Corporation Commission regulation. The town doesn't regulate railroads. And same with air quality issues. EPA through ADEQ, through PEMA DEQ, sets the air quality standards for something like this. So if
Because I had asked you, I'm sorry to interrupt, but I had asked you previously in a meeting, like making the number up, if it's allowed 40 particulates per billion, I don't have the ability to say, well, I want it to be 10.
Right.
From
Yeah.
that
So
perspective.
because that's where the DEQ permit comes in terms of air quality. Now, we will get through, these are the conditions we're going to talk about. There is one on the next slide, and we'll get there in a sec. It talks about dust and things like that. So those are going to be, there's going to be sort of a gray area about air quality, air quality measurements and things like dust or smell or things like that, smoke. But these are the things, so these are the conditions, or these are the requirements that the applicant has to demonstrate that they're going to be able to meet these conditions, that it complies with the objectives of the general plan, and Anna will talk about that in a bit, that it conforms to the zoning regulations. Again, Anna will talk, she's already sort of talked about that, but we'll talk more. It doesn't adversely impact adjacent property or the surrounding area. In other words, the impacts to the area by condition have to be substantially mitigated, not 100% mitigated, but substantially mitigated. And the other day, somebody said, well, what does that mean? It's substantial. It means mostly, or 80%. But it's even in environmental regulations, there's no 100% clean water or 100% clean air or 100%. That just doesn't exist. So that's where the town can look at what are the land use impacts, and the next slide, if you want to go to that, will kind of give a little bit more. So vehicular circulation, pedestrians probably not going to be an issue, and parking probably won't be an issue, but congestion, vehicular circulation, those kinds of things are going to be an issue. So the town can impose conditions on this proposed use that would help mitigate those impacts on traffic, congestion, those kinds of things.
Mr. Mayor?
Yes.
I just want to clarify. How about those heavy trucks on our roads? Is that something that we can have questions on that?
The challenge is going to be, I'll just give an example. So last meeting, we did a rezoning on an apartment complex out on La Cañada. And there was a proposal initially that said, well, hey, these guys are going to increase traffic, and it's going to make traffic really, really bad here, which is but it's already really, really bad here. So the analysis goes, well, what's the proportionate share that this project, or this, in that case, that apartment complex, is going to contribute to the need for, new roads or stronger roads or wider roads. And so if you have an existing deficiency on a roadway, so if the argument is these roads are already in terrible condition, or they're already congested, this is going to make it worse, the traffic study kind of analysis is simply, well, how much worse? And if you're going to have to rebuild the road, but it's already in terrible condition as it is, then is this sort of the straw that breaks the camel's back? It's not 100%. So if the town's going to commit to, say, rebuilding the road, maybe you could contribute 10% to this or 20%, but it's doubtful that you're going to be able to contribute 100% of the need for it. You can't just be the straw that breaks. You can't impose the cost on the whole camel just on that one straw.
Right.
That's probably a terrible analogy, but
Right. To piggyback off of that, John, another conversation that we had, so things like potentially a de-acceleration lane or a turn lane, but to say, build 4 lanes on Old Nogales Highway, and oh, by the way, then go to Nogales Highway, and then go to Sahuarita Road, and double our laneage, probably won't pass muster, but some things. Shane?
Thank you, Mr. Mayor. Just to tag along, I just wanted to clarify, while I'm clear on that point, John, would the town be able to designate truck routes so that they're not just willy-nilly on every road in our jurisdiction? We can say, hey, you have to take this route to use for your operations?
Yeah, in theory. I mean, again, you would want to have that substantiated or supported by the traffic analysis or traffic study that says if all the trucks have to make a right turn out, let's say, no left turn, so you can't go up Old Nogales, you have to go onto Nogales. If that can be substantiated by your traffic analysis, then sure. And they've seen it done before where project will go in, particularly when you're talking about tractor trailers, where everybody has to make a right turn out because of stacking problems, for instance. Even if there's a good example recently was a grocery store. You got all those deliveries, and all the trucks would then stack up because they all tried to make left turns, and so based on prior experience, so in this project, all your trucks have to make right turns and basically circle around if they're going to go left. So yeah,
Okay,
it is possible.
Great, because I mean, we know what our infrastructure is, we know what it can handle, and if a project like this were to go through, it would make sense in my mind to determine what a proper truck routing is so that
Yeah.
our infrastructure can support that kind of activity. Thank you.
And that's where, the town's consultants come in to analyze the applicant's consultants' recommendations or applicant's traffic studies. We would probably want to have our own traffic engineer review those, whether our experts agree with their experts. But all those things are possible, they just have to be substantiated.
Right. And probably proportionate.
Correct. It's nexus and proportionality is the constitutional requirement.
Okay, thank you. Diane?
So I see clarification. So going back to the slide that has section 1897-030 at top,
That one?
So F, the conditional use will meet standards and, no, that's the wrong one. Findings. Yes. So, C, the conditional use does not adversely impact adjacent property or the surrounding neighborhood or area. Through whose eyes?
It's part of the analysis. It's part of the consultants and it has to be, let me just back up a little bit. The conditions imposed, in its most basic sense, have to be something you can touch, feel, smell, hear, taste, So it has to be sort of factual to the senses is really the easiest way to describe it. I think you're going to, I don't know if you're sort of leading into what about diminution or what about, property values going down. There's, the whole purpose of the conditions is to try and mitigate the impact on property values, but you don't directly do that. You can't. Because that's not the purpose of a use permit. It's supposed to deal with land use impacts. There's just no way to overcome the idea, if property values drop because of the idea of something there, there's just literally nothing you can do about it. Because it's just an idea.
No, you can't ask questions. It's for us. Diane? Diane had a follow-up, Kathy, and then I'll go to you.
So my clarification that I need has more to do with health issues. So correct me if I'm wrong. So if the public or the residents around a business that wants a CUP believes that it will harm their health, but the regulatory agencies, whether it's Vulcan or anybody else, but the regulatory agencies that grant the permits say that they are within acceptable bounds, like you just said before, of air quality, water quality, seepage into the soil, then does that negate what the citizens might have to say about that standard that they may not agree with?
Well, I'm not sure it would necessarily negate it, but again, those are, to use your words, those people feel something, but the regulatory standards are what they are. So if we're talking about air quality measurements, then Vulcan needs to meet the PDEQ air quality measurement standards, which means they have to be able to show that they're going to be able to meet those standards. The town has little to no authority to try and impose a standard that's greater than what DEQ's jurisdiction allows them to do.
Okay, thank you.
Thank you. Kathy? Just make sure you talk into the mic and make sure it's on.
Sorry. What I don't understand is. Okay. What I don't understand is if they're coming out and they're doing air and health and whatever safety issues to set up standards, if the plant's not active and the fumes aren't coming out and the dust isn't blowing and the wind isn't blowing, how do you really evaluate how this is affecting the public?
Well, I would defer to the PDEQ staff that's going, if you're talking about air quality,
Air, water, land,
Right.
dust.
So in environmental law, there's sort of two ways to measure. You can measure results or you can measure technology. So, so sometimes when you're looking at how to regulate air quality, the regulatory body will impose this particular type of technology that says, if you do this, then you're fine. Or it will try and, impose a measurement that you have to achieve. And again, I'm no expert, I'm not an environmental lawyer, and I certainly don't have expertise in PEMA, Department of Environmental Quality Standards, but it's my understanding that what happens is it's measured. So if there's a violation in the future, then they'll get a notice to correct the violation.
But what I'm asking is, when do they measure? After it's already in effect?
Constantly.
Okay.
It's an ongoing measurement. So Vulcan has to come in and show how it's going to achieve these air quality standards. Then they get their permit. And then there's constant measuring of the air quality. And by the way, and this is kind of common sense, and I'm not trying to be flippant, but the air quality is not just the Vulcan plant. I mean, obviously, it's all shared. So the air quality is going to be measured sort of area-wide, not just at the Vulcan plant. So if there are other things that would tend to affect air quality, that's all going to come into play.
John,
For instance, what would be an effect?
Dust from the agriculture is not controlled. They are exempt from that, but if the mine blows a tailing, they get fined.
Okay.
They use a background standard on that.
From what I'm reading on this, and in full transparency, I live in Quail Creek. But from what I've been reading on this, the dust particles, and this is according to OSHA standards, are
Let me
full
stop
of
you right there.
carcinogens.
I'm going to stop you right there. Okay, OSHA standards are not, OSHA standards are for the workplace. So within that workplace, working at that gravel pit or working at that asphalt plant, there are going to be certain standards where they have to manage carcinogens for the employees and the workers that are there. So if you think about it in terms of the farther away you are from this plant, if ADOSH/OSHA requires that this asphalt plant be under a certain measurement of letting out carcinogens, then in that relatively confined area, then the farther, sort of common sense tells you, the farther out you go, the less likely that those carcinogens are going to have effect on people, just because it gets diluted. It's like water.
Okay, but on a day like today where there's 45-mile-an-hour winds carrying that dust, how is that not
Well,
affecting?
again, if you're talking about OSHA or ADOSH standards, they're going to have to, they figure out how to manage preventing the employees from being exposed, above a certain level to carcinogens. So if they can prevent the employees immediately at that plant from being exposed to carcinogens, then sort of, common sense tells you that as the farther away you get, the more diluted it gets. It's like polluted water. If there's polluted water there, but it gets mixed in with a lake, that pollution dilutes, and all of a sudden it's so many parts per billion or parts per million. So that's kind of how the analysis goes. So again, I am not an engineer. I'm not an environmental scientist, but that we'll talk about this too in a bit, is that there are many different layers of government that are going to touch this thing, and I kind of alluded to it a little bit ago. The town has its role. OSHA, ADOSH has its role. ADEQ, PDEQ has their role. The Corporation Commission has its role when it comes to the railroad, and maybe an ADWR has to, regulates the well water. So all of those have to come into play, and all of those standards have to be met for this thing to be fully operational.
So that is part of the conditions that we can put on the conditional use permit, is that we want these full reports
Well,
completed before
No.
we make that decision?
no, because that's not how the process works. I mean, what the town can do is say, as a condition of approval, you have to comply with all these other laws that we don't enforce, we don't adopt, and we don't enforce. But if you violate another law, and you don't correct it or cure it, within whatever time period the other agency requires you to do so, then we can initiate a rescission of the use permit. But doesn't happen just like that. It have to go through a whole public hearing process to actually rescind it. Once you grant it, it can't just be pulled administratively. Once you grant it by due process, you can pull it by due process.
Will there be restrictions to hours? When I worked for the Department of
I think
Transportation.
you're not on.
Can you, thanks.
Is that better? No. Yeah, there's something wrong with that mic. Is that better?
Yeah.
I used to work for the Department of Transportation, and a lot of the paving stuff we did was at night. When you see a lot of the paving being done on the freeway, it's done at night, especially in the summertime. Will there be restrictions on hours of operation?
Letter G. So there can be, and there likely will be. That's one of the allowable conditions to restrict.
Because you
the
see at a
hours.
lot of the construction sites, all those vehicles have backup alarms, and you hear beep, beep,
Yeah, yeah.
and, and
Yeah,
that's
no, I
gonna
mean,
travel at night.
it's very common to impose hours of operation on use permits. Because sometimes during the day, it's less irritating than, in the middle of the night. Like airports have the same restrictions. You can only fly between certain hours you can't fly overnight between certain hours. I mean, it's a very common condition of approval.
But it has to be reasonable, Raymond. One of my questions earlier to him was, is 8 in the morning to 9 in the morning, allowable?
Yeah,
But
but
that's probably not.
You see landscapers, they shift their hours in the summertime because of the heat, I would just assume that an asphalt company, I would just, in the summertime, you see landscapers shift their hours. Yeah, I think Quail Creek has restrictions about what time you can start in the morning, but that changes when you come to the summertime because of the heat. Crews get in there much earlier. So I would imagine that a plant like that and the companies buying the asphalt to do the work would also want to switch their hours of operation to night.
Well, you know, I said this on Thursday, that this process is sort of like a negotiation with the applicant. So, you know, again, if you look at the procedural requirements, the applicant must demonstrate that they're going to be able to meet or mitigate these issues. And so the town staff's going to come up with standards or conditions. Vulcan may come up with other conditions or standards. You know, the experts, the consultants are gonna, you know, chime in on those things. Ultimately, you know, those are gonna come to you, and then they're gonna come to the council. But it's, you know, the decision, it has to be fact-based or evidence-based. The conditions have to be related to what the town can control or has authority to legislate on or to govern. You know, it's important to remember that the town and the town council have only that authority that's granted to it by the state legislature. So I know somebody sent something here before from, I don't know, New York or something. Well, New York is a very different state than Arizona for a lot of reasons, but, and California is a very different state than Arizona. So the Arizona legislature has always been very pro-property rights. Has for the last 20, maybe almost 30 years, has ratcheted back on cities and towns' authorities to regulate locally, particularly with zoning. Sand and gravel is a big one. They're fighting constantly for to legislature to restrict cities and towns' authority to zone. Food trucks are another example, right? I mean, you could just keep going down the list of all the things that Uber car, you know, those kinds of things. You know, so you can only act within your authority. And this is not a cop-out. This is just the truth. Is this council and every other council in the state has been, unless you're a charter city, and even then, your authority to regulate local land use and zoning issues has been severely restricted over the last 20-something, 30 years.
And we're a subdivision of the state,
Yes,
John,
yeah.
Just to make that clear. Thanks. Dr. Gillespie?
I have a question on F, and sorry if you were going to get to this more. So it says the standards and that less noise, smoke, odors, and things like that. Those are the standards put, like, that they'll meet the standards put by these other agencies, or?
It's a little bit of both. So when we talk about standards for those, we're really talking about is the dust from the operation affecting, neighboring properties, unreasonably, or can we substantially mitigate the impact of dust? And a good example of that is whenever you see construction sites in Pima and Maricopa County, they're always watering down. So there's a dust mitigation requirement. That's a PDEQ kind of requirement. So they're meeting those requirements. So you're always trying to tamp down the dust, but as the councilman said, farmers don't have that same regulation. And driving down I-10 today, it was like a haboob with, because all the fields had been plowed and the wind was blowing, west to east, just massive dust across the highway. So those are the things that, like I said before, if you had a windy day like today, there's no way that you can say, well, Vulcan's creating more dust, because dust is just a, sort of a natural thing. But things like odors, vibrations, fly ash, fumes, vapors, it's liquid and solid waste. The whole idea is to minimize that, but it's not feasible to try and 100% prevent it.
But this is a category where we have more
Yes.
say.
Yeah.
Okay.
I'll give you, for instance, noise is a good one up there. How do noise and hours of operation kind of go hand in hand. During the day, typically, you're allowed to make more noise than during the night. But at the same time, there are ways of, either technologically or and a big one was the fumes or the smell. There are things we can look into, and again, this is going to come from our consultants about, are there additives that you can put into asphalt that reduce the asphalt smell that's just inherent in an asphalt plant? Or is there some sort of scrubber or something like that? But, it has to be, the requirement has to be achievable too. It can't be some futuristic thing that doesn't exist yet. It has to be, so if there is an additive, then that could be a potential requirement.
John, can you touch on, and I'll go to you, Shane, touch on the wall conversation we had? So if you're at a certain decibel now, let's say a 30-foot wall would be, but I can't say a 200-foot wall
Right.
if it takes it down, if you want.
Yeah, so, it's I think Bill and you may or know, that in the military, we have the 80-20 rule, that basically 20% of the effort gets 80% of the job done, and the rest of your, 80%, you're just kind of, you're really spinning your wheels. And so the analogy is that if you can require a wall to be built or some sort of sound buffer to be built, whether it's trees, landscaping, walls, and it reduces the sound by a certain percentage, but adding another 5-10 feet would reduce it by another 2 or 3%, that proportionality starts to go away. So again, it's substantial mitigation. It's not 100% mitigation. That's the standard you have to remember. And you can deny the permit. Don't lest anyone think you can't deny the permit if you can't come up with conditions that substantially mitigate the problems. But the job of the staff and the commission and the council is to figure out, are there conditions that we can come up with that can substantially mitigate the problems?
And Shane, I know you-
And the applicant, by the way.
Right, thank you. Shane, did you have a comment?
Yeah, thanks for adding the applicant, because really, I think the burden of all of this falls on the applicant themselves to prove up what they are going to propose to mitigate these things. And then the ball's then in our court to question that, to challenge it, to push the limits and see, okay, what's within the realm of possible.
And validate it.
And validate it.
Validated.
I would note that I kind of look at these things that obviously there's an overlap. When you're talking fumes and vapors and gases in the air, there's the regulatory agency that's not us. It's ADQ or the county that gets involved with this. But I view this as being, okay, the town's going to take a stab at making sure there's no gaps here. And what's clear to me is that we can't supersede a higher jurisdictional authority like the county or the state or the federal government. But we can look at things like odors and dust. Is there technology? One of the gentlemen the previous night suggested some kind of application, not chemical but equipment. Like, is there a scrubber that can be affixed to this that would help? I think all of those things need to be looked at, and we have a consultant on board to help us process what we hear back from the applicant and to make sure we're asking the right questions to get the answers that we need to make a good, well-informed decision by the commission, by the council. So, that's how I view these things. Even though looks like there's an overlap and that we can just jump in and do what we want, there are other jurisdictions that we have to acknowledge in this process. Thanks.
Vice Mayor?
Thank you, Mayor. There are many residents that would like us to vote, if it comes to us after it goes through the commission, to vote no to this because they don't like it. If a counselor were to do that they didn't have legal reasons to do that, what would be the process? I'm assuming we would get sued, but I thought it would be important
Probably.
to put out that process.
So the legal process would be that, the claim would be that the town acted arbitrarily and capriciously. And the end result, the worst case scenario is, kind of three areas. One is the judge could order the town to issue a use permit with no conditions. In other words, you may not only lose the, Sorry. Okay, really? I've never been told that before. So, if the town votes no, it's one thing, so it's a couple, three options. One, you vote yes with conditions and Vulcan agrees to the conditions and they go on their way. Two, you vote yes with conditions and Vulcan doesn't like the conditions and they sue on one or more of the conditions to get those overturned as illegal or unconstitutional. And then the third is to deny it altogether. If you deny it altogether, and it's considered arbitrary by the courts because of the facts and the evidence and everything that's presented, particularly by your own consultants possibly, the judge could essentially order the town to approve the use permit or to issue the use permit without any conditions. So you kind of, not only you lose the war altogether. Second problem with that is there's a likelihood that you're going to get hit with their attorney's fees, which, it's not going to be millions, but it could be a substantial amount. But the worst is that if the town denies a use permit, illegally denies a use permit, there's a potential to be hit with what's called the regulatory taking or a temporary regulatory taking. So the time from when Vulcan, they're going to argue when they should have had the permit and began operations to when they ultimately get the permit through the court process, and it could be less than a year, it could be more than a year, is all lost revenue and all lost income. And I don't know what that looks like in the asphalt plant world, but it could be substantial. And that could be the takings damages that the town gets hit with. And that's probably not covered by the town's risk pool insurance. So I get it, I've heard this in many, many different places. Well, just let them sue, and it's great to say that, but you have to be able to pay the piper when it comes down, particularly if you don't have a real good shot at defending yourself. What I do as an attorney is try and give you sort of options that are defensible. And like I said, I'm not telling you that you have to approve this. I'm telling you that if you don't approve it, you better have some darn good reasons. And basically those are, we can't come up with conditions that substantially mitigate all of these problems, and Vulcan couldn't essentially. And by the way, there's one other, I just want to interject. I know a lot of people talked about the safety issues of the fire department. That's another jurisdiction that's going to be responsible, and that's the fire district. And so they're going to have to, and so the town staff will get the fire district's input. Is this something you as the fire district can handle within your, within your current services, or is there something the fire district's going to need, whether it's equipment or something?
And with John, to that point, if there is something that is needed because of hazmat or whatever, is that a potential condition?
Yes,
that
it's
you-
a
it is?
potential,
Okay.
yeah.
Thank you.
I have a question. I've got a couple of questions here. Okay, we've kind of gone through health and safety issues here, but what about the game and wildlife? Do they have any say in this? I mean, it potentially could affect the wildlife in the area, along with the box turtle, which is an endangered species that is in this area. And this is one of the biggest migratory paths for birds and butterflies in the United States. Bird watchers come from all over the place. I'm not one of them, but this is all of Madeira Canyon is full of tourists and bird watchers. And this pending dust and chemicals and fumes could have an impact on this. So I feel like we should have a report from the Fish and Game and Wildlife Societies, and the migratory birds are under the Department of Migratory Bird Treaty Act and their regulatory system. So I'm just putting this out here, that it's not just the people or just the residents of Quail Creek or the children that are across the street at the playground that are being affected by this, but we're talking wildlife, we're talking groundwater, we're talking air pollution. So these all things kind of trickle down into different things. I feel like we're better off stopping this before there's a problem than after there's a problem. I feel like, I just feel like somebody's got to be responsible for the people in this area that are retired or that are are raising families and bringing children here. We don't know if there's going to be an effect on fertility, sterility of fetuses, of pregnant women. All these things are a factor. And, I know we're being flippant. Well, they'll modify it or they'll spray it down. But we really need to know these things before we allow this to happen to our public, that we have guaranteed come to this nice, quiet little area and live out the rest of your lives or raise your families. Sahuarita's got the best school systems in the world. But don't just ignore the poison that's in the air. That's just nonsense. So somebody's got to be responsible for this. And if this board isn't responsible and we're not responsible, who's responsible? You keep saying, well, it's the county or it's the state.
Is there a question in here?
So I'm asking, who's responsible?
Well, we'll get, if we're going to go, I think, is it the next slide? We've already talked about that. So we talked about this on Thursday, and basic civics tell us that there are many different layers of government and levels of government that have certain responsibilities and authority. And so the town's authority is limited to land use impacts on this.
Okay, I understand that.
And these are the list of, and you could include Arizona Game and Fish, whether they're having involvement on this, I don't know. It's hard to argue that somehow that, and again, with all due respect, it's not how you feel. It's what you can prove and what you can show.
Okay, I understand that.
So,
but-
not what you say, don't tell me, show me. That's an old cliche,
Okay,
right?
I
So-
understand, but nobody showed the people of East Palestine, Ohio, what could happen, and look what happened. I don't want to be on the national news as this could happen.
We're talking about an asphalt plant. I mean,
Yeah,
which
and
there's a prevalence
We're
of.
also talking about a train track that's going across. We're talking 300 trucks a day that are going across that train track. How easy could a derailment be?
That's right there. That's the Union Pacific Crossing and the Corporation Commission.
Mr. Mayor?
Right.
Yes.
All due respect to the level of questions that are being asked, I need to just remind the group that we have to be true to this process.
I
No,
understand
ma'am,
that.
hold on, please. We run a risk, if we're not true to the process, of really messing it up for this whole community. And so we absolutely need to allow the public hearings to happen, for the applicant to come in and take ownership of their impacts and suggest to the public, to the commission, to the council, what their remedies are for that, and then allow the town to rebut and to press for the demands and the needs that we have as a community. If we start now in going down a path, you as a commission, I'm being very direct, you as a commission and you as a council, drawing up conclusions in advance of those public hearings where the applicant can stand in front of you and defend themselves because they are a property owner and they have rights. I'm making it publicly known that we run a very big risk as a community. So I would strongly recommend that we not draw conclusions in our minds, in our hearts. We allow the process to play out, and we hear from the applicant, we hear from the public that's there to participate and engage in that process, and we hear from staff. and we allow the process to play out. I'll
And-
close
and
right there.
I agree with you wholeheartedly. All I'm trying to do.
Ma'am, that's not what I'm hearing in the tone of
Mr.
your
Mayor.
questions. Thank you.
Well, I'm sorry, but I'm trying to speak loudly into this microphone.
No, there
And
was
what
no-
I'm trying to ask is, I don't feel like we have taken into consideration all the
We haven't done
different-
anything yet.
Point
Just
of
let's-
order,
let's-
point of
let-
order.
let's just
This is
clarify.
not on the agenda. This is a study session. We're not solving this problem here tonight.
I'm not asking to.
Yes, you are.
No, you didn't let me finish.
You've been going on for minutes, longer than anybody else.
Point
So
of
don't say
order.
you haven't finished.
So what I would recommend is we stop John and went on a rabbit hole, like, good information on this one particular side. So I'm going to have John continue. We'll take, notes, and there'll be other opportunities. But to Shane's point, if we, as a commission or as a council, already are feeling predisposed of the outcome back to the applicant's rights, then we're in a bad situation.
Quick question on,
The public has rights too.
We all do, and that's why we have public hearings, and we have further opportunities to do that. So, John, does anybody need a bathroom break? Or we could take a break?
The
We were just
commissioner
talking
had
about
a-
it was
Mayor had a
just a quick
question.
question on the rebuttal is during the same hearing on the commission, or can we propose, I think in the past we've had hearings where we can propose additional study, recommend study, or what is the steps of what you were describing of response
So,
to
I mean,
their
in your public
application?
hearing, you don't have to conclude that public hearing. I
Right.
mean, if you get into that public hearing and there is due process yet to be had, you can continue that public hearing to have yet another.
Okay.
So
Public hearing.
it allow us to just get into the process. Right now, staff's completing their analytical work. I know that we're going to be forwarding a lot of the community's concerns that we've heard, in great number from the Quail Creek and just community at large. We're gonna forward to them a list of concerns that we're gonna expect their feedback on as part of this public hearing process.
Thank you.
And then we can respond.
Thank you.
Thanks. I was going to make that point a little later, Dan, about that. No, that's okay.
So-
That, typically the public hearings, pretty much you already know the answers and we just sort of go forward. But there are times when new things come up, you're not satisfied, you can continue a public
So,
hearing. till
Mayor,
you're
just
satisfied.
a kind of a point of order. As we learned in the first part of this meeting, this sterling lecture on open meeting law, the Planning Commission has lost its quorum.
Oh, okay.
So, and I don't know, from a forum standpoint, obviously the council's here, whether they continue sitting there or go in the audience or whatever, but, the commission unfortunately has just lost its quorum, so it's kind of, we have kind of an issue there.
But there's no business being conducted.
Well, you still
Shane-
can't have a discussion.
Right, Shane, let Shane go first, and then, obviously, this is the beginning of a process, the three left that are sitting in front of me. So obviously, we can take questions later, just like we do from residents later. But Shane, make your point, and then I'll see what John thinks about that idea.
I would just recommend, because we've lost the quorum, that those of you who are sitting here on behalf of the commission, take a seat if you'd like to continue with this presentation and hear the information that we have to share. Just know that you're doing so as a member of the public and not as a commissioner at this point.
John, should they adjourn, the vice
Well,
chair adjourn?
It's sort of automatically
Oh,
adjourned
because
by
it's
default.
by default we've adjourned.
But,
Thank you.
Yeah, sorry about that, but, so just real quickly on this jurisdictional issue, there may be, and this list isn't exhaustive of other government entities, it may be Game and Fish is involved, or, ADOT might be, I don't know. I
Right.
mean, again, but we're talking about that government authority tends to be sort of stovepiped in this way, in this kind of decision-making. It doesn't overlap that much, although we did, when one of the conditions talk about dust and those kinds of things, those are environmental issues, but the specific regulations are gonna be DEQ, and then if there is, some dust or other things that the town can, that essentially is not regulated or outside the regulation of DEQ, then, the council can, or the town can look at conditions that may help mitigate those issues.
Thanks. For right now, why don't you continue, because I'm
I
sure we'll
think
have some.
I'm done,
You're done
Anna.
with that
Next
part?
slide. Oh, that's Anna's.
Back to Anna.
All right.
You didn't fall asleep over there, did you, Anna?
Way too exciting to fall asleep. Thank you, Mayor Murphy, members of the council. I'll continue with a little more information on how the conditional use permit process works. There are 3 different types of CUPs. The process is specified by the code, so each chapter of the zoning code lists permitted uses for each zone and then a list of conditional uses. And for each of the conditional uses, the code tells us which process to use. We don't choose that as a staff or as a council or a commission. The type 1 CUPs are going to be your least intense uses, the ones with the least potential for adverse impact, and those are a planning director decision with public notice. A type 2 CUP is going to be your more moderate level of impacts, and for those, we hold a public hearing before the Planning and Zoning Commission, and the Planning and Zoning Commission makes a decision on those. The type 3 CUP is the process that we are in right now for the Vulcan asphalt plant. And that requires a Planning and Zoning Commission public hearing and recommendation, and then a Town Council public hearing and decision. So for the type 3 CUP, which is what we're in right now, the first step is for the property owner to apply to the town for the CUP. Once we receive that application, we start the review as a staff. We review the application against the standards established by the town code, and we make a recommendation to the commission. During that analysis period, we have an opportunity to ask the applicant for more information, and that's where we're at right now. We've almost completed the first review. We're planning to get a set of comments out to the applicant this week, and then they have an opportunity to provide us with more information to help us in our analysis. Once that is completed, we will formulate our recommendation and take that to the Planning Commission. There will be a noticed public hearing. The opportunity for the public to comment happens at that public hearing, and the commission will make a recommendation to the council. We then advertise a subsequent public hearing for the town council, and the public again has an opportunity to comment, and the council makes the decision. What goes into the analysis? We've already talked a lot about this, so I won't belabor it, but we have our 7 CUP findings. Just to sum those up, we look for compliance with general plan policies, conformance to zoning regulations, adverse impacts. If there are any, are they substantially mitigated? We look at adequate vehicular access and circulation. Are we served by utilities and services at the site? And does the application meet standards for noise, smoke, glare, odors, pollution, etc.? We also look at the hours of operation to determine if they are detrimental to the public or not.
Anna, do you mind just pausing there for a second? John, we're back to a quorum. Kathy returned. We'll just come back to the table?
Yeah, you can just come back to the table.
Okay.
I'll just give everybody a couple seconds.
I apologize, I just needed a bathroom break.
Oh, I'm sorry, I didn't hear that.
You said take a bathroom break. And I apologize to the gentleman, the first gentleman down there, for asking questions. I thought that's what a work session was for, to ask questions. So I will not ask any more questions tonight. Thank you.
Well, that's not necessary, but, we're trying to get through the presentation and
Presentate away.
please continue,
I will
Anna.
continue presenting. Also, as part of the analysis, we request a preliminary development plan from the applicant. This is also called a site plan in some jurisdictions. This is essentially a little map of the property showing where they're going to put the buildings in relation to property lines, how traffic circulation is going to work. It's a very high-level view. It's not the nitty-gritty of how the site's going to be developed out. That comes a little bit later. In this case, we have brought on a third-party consultant to help us analyze the impacts and mitigation strategies. We have hired Nino and Moore. We're asking for help from their environmental engineers to review this application. We don't have that expertise on staff, so bringing in these environmental engineers is really going to help us determine what the impacts are going to be and to review the mitigation strategies that Vulcan will propose and whether we need to bring in more conditions. One of the things we're going to be heavily leaning on them for is odor mitigation, to see what's the best route for our community if this thing does go through how to best mitigate those odors.
And that gentleman, I think it's Mr. Floyd, that mentioned that regenerative oxidation, something or another. Those are the types of things that it's helpful for us, right? To learn about these new technologies that you could pass on to our consultants, correct?
Yes, that's exactly what we're going to be using them
Thank
for.
you. Diane? Sorry.
So clarification, is it one consultant, one human being, or is it a firm that has a wide range of expertise in all of the areas that would concern our town?
Thank you. That's a great question. It's a firm. Nino and Moore is a firm, and we have at least 2 different people at that firm looking at the application.
Does this firm have the wide range of knowledge? For example, Kathy was bringing up her concern over the wildlife and the animals. Does a firm like this have expertise in that too, so it could be something that we could expect from them or ask of them?
They are environmental engineers, so that's something that environmental engineers look at. So we
Okay.
will be making sure that they're looking at those types of impacts as well.
And then we can use that to come up with conditional
Conditions.
conditions to propose to Vulcan.
Yes.
Okay, thank you.
Yes.
We talk about us coming up with conditions. Can we put some of that burden on Vulcan?
Yes, yes, we can do that. Mayor Murphy, members of the council, members of the commission, we are asking Vulcan as part of our comment letter to go through each of the 7 standards and explain in detail how they plan to mitigate for these things. Once we get their specific mitigation strategies, which will be formalized as conditions of approval, we'll have the consultants review those and tell us whether those are adequate measures or not. And if not, then the consultants can help us come up with further conditions.
And
it looks like Shane has a comment as well.
Just real quick, Anna, thank you. I think what I would like to do is I'd like to take the collective feedback from the public that we've received. There's common threads in all those emails, but generally take those common threads and have Vulcan assign those to one of these 7 points within the conditions, and then so that they're assigned some place, some home in our code, and then respond as to how they're going to mitigate those concerns and satisfy those conditions in our code. That way, it's all tied together, and we can systematically go through and make sure that we are looking at every aspect of the code and all the concerns that have been brought forward by the public and what staff has generated on our own, and make sure that we're again systematically going through and addressing all of those. So that's how I'd like to proceed.
Thanks. Dr. Gillespie, did you have a follow-up, or did Shane take care of that?
Great job, Shane.
There. I think that's a yes.
I have a question. So, with all the public comment, it's very difficult for the commission to digest that comment in a short amount of time. If you're receiving public comment, is there any way to get the comments that have been received so far, or any preliminary analysis by the staff to the commission ahead of the meeting, so we can study those a little sooner?
Yes, that's great. We have almost 600 emails saved. I think this morning we hit 525 individual email addresses that have sent comments in. We're collecting all of that. It's a lot to get through. I've done very little else other than read public comment on this for the last couple of weeks. So yes, you do need some time on that. And we'll make sure we get those out to you as soon as possible. And we'll also go through and put together, like I think Shane said there were some common threads.
Right.
We'll put together essentially an executive summary of what those comments are to help you get through that a little bit more quickly.
I understand that the town needs to process the information too and summarize it. Sometimes it's helpful for us to get the raw information, such as the public comment ahead of time, because last time and this is no criticism, it's merely, I think, a better way to do things is if there is a lot of public comment, don't wait till the very last day or the day before the commission to be able to inform us of what that is. And that has happened. I just want to be able to prevent that from the future so we can really digest that. That's just one of the requests that I'd like to see in the future.
Yes, thank you, and I'll work with our clerk's office to make sure we get that out to you as soon as possible.
Does, as they are applying for their conditional use permit, do you know if they have a secondary plan? When we listened to the apartments for La Cañada, they had a plan A, plan B. Do you know if they have any other applications in for asphalt plant in the area, or is this the only one? It's all or broke for this?
That's a great question. I'm not aware of any other applications that they have in with other jurisdictions, but it's certainly something we can ask.
Okay.
And I should have mentioned earlier, we also have a consultant on board to help us review the traffic study that they submitted. So they'll be helping us take a look at all those traffic numbers and any special conditions we might need based on their volumes for things like deceleration lanes or turn lanes or any of those traffic specifics. They'll be helping us with that.
To include a possible light as well, correct?
Right.
Thank you.
Mayor,
Yes.
I'm having a hard time wrapping my head around 300 trucks a day. You know, do they even own 300 trucks, and where would 300 trucks of asphalt go? Is there any way we could put a condition to that and limit how many trucks they can have?
Councilmember Morales, it's a great question. I think it's an appropriate question for the applicant to respond to. No doubt in their application, they're thinking about the future. And so they are putting together not what they'll need right out the gate, but what they're going to need long-term. And so I can't speak for the applicant, but that's a great question for the applicant when they're standing in front of you.
Thank you. Continue, Anna? No, for the study session.
Okay, thank you, Mayor Murphy. As we go into the analysis, one of the things we look at is the general plan. The general plan is a policy document. It's not regulatory. The general plan has a few different main components to it. One of the major components of the general plan is a land use map, and up here on the screen you see a snippet of our land use map. The Vulcan site is outlined in red. You can see it's gray. The gray is resource industrial. The Quail Creek area and Madera Highlands south of Quail Creek are both in the crosshatch. That's a specific planned community. The orange is a medium density residential, and that is owned by state land. So when we review a rezoning, which this is not, one of the first findings we have to make in order to even process the rezoning is whether the zoning requested for a property is in conformance with the general plan land use map. In this case, we are not doing a rezoning. It's a conditional use permit, so that's not a required finding just to process the application. But what we do have to do is take a look at all of the policies in the general plan. We'll be going through each individual policy in the plan and looking to see whether this application is supported by the policy or not, and we'll present that during our analysis. One thing I wanted to mention was we've heard a lot of comments about the resource industrial land use designation next to the medium density residential designation not being appropriate. State law, I think it was back in 2019, required jurisdictions to protect aggregate uses in our general plans. Aggregate is the sand and gravel operation.
Right.
That's what they call it, as aggregate. So the resource industrial land use designation on the general plan map has been in place actually prior to that. We had already called it out because it was an existing operation. We were also required back in 2019 as part of that state law to put a policy in our general plan protecting that aggregate use. One thing I want to mention here, mostly for the members of the public who are in attendance, I know the commission and council are already aware of this, but the general plan is, like I said, it's a policy document. It's not adopted by ordinance, it's adopted by resolution. The regulatory document is the zoning code. So the general plan is essentially a very strong suggestion, where the zoning code is a set of rules. So we'll jump into zoning a little bit now. Here you see the same map, the same zoning map with the green and the blue. The yellow, once again, is the approximate location of the hot mix asphalt plant. The blue is Quail Creek and Madera Highlands. The Vulcan site is zoned RH, which is rural homestead. The RH zone allows a variety of uses, including residential, agricultural, and industrial. The more intense uses in the RH zone require a CUP process. Some examples of those are animal racetrack, commercial feedlot, tavern, and fairgrounds. Also, sand and gravel operation, including asphalt and cement plants. That appears as number 23 on our list of conditional uses for the RH zone. So here you can see a snippet from chapter 18.13, which is the RH zone. You can see it calls out specifically the type 3 procedure. It has a special notification area of 1,000 feet. Normally a CUP has a 300-foot notification radius where we have to mail notice to property owners prior to the public hearing. The code does allow us to expand that, but it gives us a maximum of 1,200 feet. In this case, we did recommend that the applicant notify out to the 1,200-foot radius of the neighborhood meeting, which was held back in January. Quail Creek is about 2,500 feet away, so they are well outside of the required mailed notification list. But we know that people are affected even outside of the mailing radius, which is why state law and town code both require 3 different means of notice. So in addition to that mailed notice within the specified radius, signage will be posted on the site, and an advertisement will be in the newspaper. And those will
And the
announce
people on the email list will be notified
Correct.
as well.
All 500 plus email addresses that we've received so far will receive a courtesy notification in an email when those hearing dates are set.
Thanks. Diane?
Anna, could you please explain I want to make sure I understand letter B under conditional uses?
Sure. Letter B, for those of you in the audience who can't see it, it says, it's a little bit confusing. It says minimum front site setback 300 feet from any property line.
Yeah.
So this is some language that was adopted from Pima County. When the town incorporated back in the 90s, we just adopted the Pima County Code. And there's some interesting stuff in the old zones. We're actually redoing our residential zones right now, specifically because of things like this that are rather confusing. So what the code does under a lot of the different conditional uses is that it establishes a special minimum front site setback. Each zone has setbacks that are established, and 300 feet is significantly more than the standard setback in RH. So here they're calling out a minimum front site setback, but then saying 300 feet from any property line. So my interpretation of this would be that the intent was that there be a 300-foot setback from any property line, not just from the front property line. So we'll be looking for that on the site plan for that 300-foot setback. And what a setback means is you can't have structures or land use in there. So you can have your landscaping, you can have, like, say, your berming or your sound wall or parking lot, but you wouldn't be able to have your, in this case, asphalt plant buildings within that 300-foot setback.
Does the CPU have a expiration date, or is there a time frame that becomes reviewable? Because I'm assuming that Vulcan feels like there's a need for an asphalt plant down in this area to lower some of their fuel costs. So they're going to want, now, as those projects start to develop and they're over, does the town go back at any point and review that CPU?
Yes, that's a great question, members of the council and the commission. There are time limits established in the code. There's a time limit by when they have to pull permits to start the operation. So if they say we approve the CUP and then they don't do anything for 3 years, I don't remember off the top of my head exactly what that number is. I want to say it's more like 12 to 18 months that they have to start operation. Then they have to reapply. So they can't just let it sit out there and hang and not do anything with it and then come back years later and try to start back up. And the same applies if they start operation and discontinue. If they discontinue operation for 12 months or more, they need to reapply for a CUP. So in your example, they're doing this because there's a big road project, the road project finishes, they stop the operation. If 12 months go by and they want to restart, they need to come back and do this process again.
And to that point, if things have happened negatively during that time, is that allowed to be brought up at the next CUP process to help further mitigate that if in fact there was any problems.
Yes, I would say so. If they are in operation and we find there are adverse impacts, they stop operation and come back, then we have a really clear idea of what those impacts are and either choose to impose additional conditions to prevent those impacts from happening again or go a different route.
Okay, thank you.
Now, we lose that right to review if there's a court action, if they decide to sue. Do we lose all that right at a review of that conditional use permit?
Well, that's a little bit hypothetical, but given the question earlier, if it's a court-ordered use permit, there are no conditions most likely. In other words, if there's a denial and the court finds that it's an arbitrary denial, the grant of or the order, telling the town that you have to let this operate, there may be no conditions. So that's the risk you run if you don't have, a basis for a denial.
Thank you. Continue, Ed.
Okay, the next steps in our process are for staff to complete the analysis and for our consultants to also complete their analysis and get their findings back to staff. We will schedule, advertise, and hold public hearings. If the council approves the CUP, the development review process is required, so we'll have to get a development plan from them, and this is where we go into more detail on traffic, drainage, etc. They have to provide very detailed engineering plans of how they are going to manage their traffic and their runoff. We'll also require that they demonstrate how they're going to be providing the required screening, if there is any. It's really the detailed portion of the site review. We've got some information here for how the public can get involved. Many people have already figured this out, but you can send your comments to mayor and council at sahuaritaaz.gov. If members of the public have already sent in comments or signed a petition, it is not necessary to send comments again before the public hearings. We're keeping all of those comments, and everything we receive will be presented to the commission and the council. So you don't have to provide your comments now and then provide it again for the commission meeting and again for the council meeting. They're all being aggregated and they'll all be presented together. Anyone who sent in comments, like I mentioned earlier, has been added to a contact list and will receive courtesy notification of the meetings. We do have project information online. There's a pretty long URL up on the screen right now, but we've added a link on our homepage. So if you just go to sahuaritaaz.gov and scroll down, there's a little announcement, and if you click on it, it'll take you to a link that has more information and the project page. Meeting dates will be announced. We've been talking about a tentative public hearing date of May 23rd. That may or may not happen, so do stay tuned for those dates. Check the website, members of the public, and make sure you're keeping up to date on those dates, because it's subject to change depending on how long the applicant takes getting their response back on our comments after we send our comments out this week. Public notice will be provided as required. We talked about the 1,200-foot expanded mailing notice. Signs will be posted on the site, and we'll have our required advertisement in the newspaper.
Thank you. Councilman Davis.
Thank you, Mr. Mayor. Couple of quick questions. Cost on the town hiring the experts and folks involved in obviously reviewing the CUP. Is that something the applicant covers, or is that on the town's dime? Talking the costs of the CUP, hiring the town, hiring the experts, does that fall to the applicant, or is that a town expense?
That's a great question. We do have a fee schedule that was adopted by the council, so the applicant has paid their conditional use permit review fee. As far as the special consultants, we're treating that as a pass-through cost. The fee schedule allows us to do that. So whatever we end up getting charged by the consultant will be forwarded to the applicant, and they'll reimburse us for that.
Thank you. So that also prevents us from having to be too careful, I guess, of not, back to Diane's question, we can employ anybody we need to based on comments or concerns that we forward over to you, correct?
Correct.
Thank you.
Mr.
Okay,
Mayor,
then second question on that.
Let me just be clear on this. For the public's benefit, the consultants are paid by the town. So they are on our payroll. We pay the consultants their bill, and then we recover those costs from the applicant. So it's not, the applicant has no bearing on these consultants.
Right, or who we hire.
Right.
Thank you. Councilman Davis?
Okay, the second question I got is more a question of timing. In this case, there's other jurisdictions having authority on access to this property. They are renowned for taking years to come to a resolution on traffic access, things like that. How will that, I guess my question is that if the town approves the CUP, but the other jurisdictions don't put in their approval for an extended period of time, how do we handle that?
Thank you. One thing we've talked about as a staff is putting a condition on the CUP that they obtain all the other required approvals. If they are, say, unable to get a permit from UPRR for a rail crossing, then that's going to end up stopping the project. So just because they have our approval, they still need to follow through all the other agencies' processes, and any one of those could end up putting a stop to it if they're unable to get their permitting.
Right. Much like the mines over recently, whether it's a judge or the Forest Service in the case of Rosemont, any of those jurisdictional agencies can be the barrier, not necessarily just us locally.
Tom?
Yes.
So Anna, but we can put that statement in as a condition that all of these others, so it doesn't kick, we haven't in fact approved it if somebody else denies their permit.
That's correct.
Okay.
Sort of like we've done previous with residential. Yes, but you have to go get sewer and railroad crossing and water and yada, 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 down there. Did you, Debbie? To my left?
Mr. Mayor, I
Yes.
just wanted to, I don't have a question actually, I just wanted to speak to the public actually. I hope you know that we're listening. We have to be very careful about making judgment before we hear from the applicant in the whole process. We have to allow the process to occur. So I hope that you don't think that it's coming not to deaf ears. I know many of these council members have read all of your emails, and I have never received so many emails about a subject ever in all of the years I've been on the council. So we are hearing you, but just please allow us and allow the town staff to work through this process. We want to represent you guys, but we have to also follow law, and so it's going to be a balance as we move forward with this process.
PNC, any last thoughts or comments?
Yes, there was no mention of vehicle damage, but I feel like this doesn't fall under those types of impacts from the company. So those will later on be acknowledged?
What type of vehicle
What do you mean?
damage are we referring to?
Like if there's spillage from the haul trucks on regular roads from the residents driving around and they get fly rock on their windshield or anything like that. That's going to be totally separate.
Well, if you're, it's a ticketable offense if if your, whatever your load is flying off. So that could be a police enforcement action, but, Arizona is probably the worst state in the country as far as broken windshields.
Right.
I mean, I'm not trying to minimize it, but we can look at imposing some type of condition, but at this point, as has been said, we don't know, what their operation is really going to look like. I mean, they have their application in and what their day-to-day operation could look like. So what are the kind of vehicles that are going to leave with the asphalt? How is it contained? Is there a chance for sort of the spillage? Those are all things that can be looked at, because those are some of the types of impacts that are kind of immediate to the project or to the proposal.
Thank you.
Thank you.
So,
Dan?
when does the application that they submit get reviewed? When have they submitted preliminary information, Vulcan has, or, and just maybe a side note, have they submitted other applications to other towns that could be used as information on how they have operated in other towns?
Thank you for the question. They have officially submitted, so the review process is underway as far as the timing. And as part of the analysis, we are looking into some of their other facilities that they have in the area and throughout the state. So I've been trying to dig into some of the other facilities, like there's one at Valencia and Old Spanish Trail. There's one in Marana. So I've been talking and requesting public information on those to see if there have been any conditions of approval placed. I'm finding that most of the ones I've asked for happened under county regulations and under mining exemptions, so they haven't had a lot of permitting processes that have applied, but all of that information will be put together for you as part of the analysis.
Thank you. Vice Chair, did you want to adjourn your P&Z? Oh,
Are there any other questions from the commission?
yep, go ahead. Turn on the mic, please.
Is it on? Okay. Two things I really wanted to ask before that I didn't get to. Is part of the environmental agency that you're hiring, will they take care of any of the agricultural research, such as the pecan groves and how they might be affected?
We can ask them to take a look at that.
Okay, otherwise, I guess there is under the USDA an agricultural research services that we could ask for a report from them. And the last thing was I've brought this up once before, because there is only one exit out of Quail Creek, Madeira, et cetera. I'm concerned about an emergency, such as a fire or a train derailment or some problem, and I just would like to see, I think it would appease a lot of the residents too, if we had an emergency evacuation plan in place for Quail Creek, Madeira, Madeira Highlands, and Stonehouse, along with La Posada. Is that me?
Did you get that question, Anna?
Thank you.
Yes.
Yeah, thank you.
I don't know if that's something that could be done through the environmental agency too, or if that is something that the fire and police and EMTs would do. I don't know, but I just think it might help a lot of the residents that are in fear of all of what is going on and the possible indications from it, if they had some type of plan in place.
And we do have an emergency operations plan. The town has gone through that exercise. So it's not something that hasn't been considered. And I've also spoken with the fire department about hazmat. They said they're fully equipped to deal with hazmat situations, and they've been provided the application, and they have an opportunity to comment as well.
Okay, good. Thank
Thank
you.
you.
And one reason that the fire department was put on the other side of the tracks was exactly that.
Right, to be able to get
Because in case
there.
there's a derailment or a blockage.
Right, thank you. I'm sure that's part of the comment that they'll be responding back to. Shane, did you have any last comments to wrap up?
I didn't, Mayor. Thank you. I think I've spoken enough tonight.
Thank you. Never enough. Vice Chair, did you want to adjourn your P&Z commission?
No further comments. A motion to adjourn? Second? Okay. Thank you.
Thank you for being here and having no more we do have a regular scheduled meeting on April 10th. Councilman Bracco said we didn't have enough meetings, so we're going to have them almost every Monday. Having no more further business, we're adjourned.